session. The Honorable Judge Candace Smith presiding.
Please be seated. Good morning, everyone.
Good morning.
Good morning. Welcome to the final round of the 2020 Kentucky High School Mock Trial Competition. My name is Candace Smith. Since 2010, I have been serving as the appointed magistrate judge for the United States District Court for the Eastern District of Kentucky with a duty station at Covington. It is my pleasure to serve as your presiding judicial officer for this morning's criminal trial in the case of State of Utopia versus Quinn Penner. We do have a number of people who are here in the gallery for this public courtroom, and so just a few reminders to all of you. During the trial, please be sure that your cell phones are off, and if you need to leave the courtroom, please do so quietly, and if you can, try to do so at the end of a witness's testimony. We will be taking a 5-minute break at the conclusion of the prosecution's case in chief, and also before closing arguments then. Are our jurors ready to proceed? Right? Thank you, thank you. And is counsel ready to proceed?
Yes, Your Honor, the defense is ready to proceed.
Thank you.
Yes, Your Honor, the state is ready to proceed as well.
Very well. All right, thank you. At this time, then, I would like to hear introductions from the parties, and let's go ahead and begin with the prosecution, please.
Yes, Your Honor. Good morning.
Good morning.
My name is Everett Parker Nobley, along with my co-counsel, Shreya Holla,
Good morning, Your Honor.
Good morning.
and Katie Tolliver.
Good morning, Your Honor.
Good morning.
And collectively, we represent the state of Utopia.
Thank you.
Our witnesses in the order they will be called today are Ms. Lee Hayes,
Good morning, Your Honor.
Good morning.
Mr. Chris Minson. Good morning, Your Honor.
Good
And
morning.
Ms. Jamie Spalding.
Good morning, Your Honor.
Good morning.
Now, would you like opposing counsel to make appearances first, or should we go into pretrial matters?
I would like to hear from the defense as well, please, as far as introductions.
Yes.
Thank you.
Good morning, Your Honor, members of the jury. My name is Sydney Skaggs, and I, along with my co-counsel, Miss Alyssa Bosley,
Good morning, Your Honor,
Good morning.
members of the jury.
and Miss Sydney Shoemate,
Good morning, Your Honor, members of the jury.
Good morning.
represent the defendant, Quinn Penner, in today's case.
Good morning, Your Honor, members of the jury.
Our witnesses today will introduce themselves.
Thank you.
Good morning, Your Honor, members of the jury. My name is Naya Phelps, and I will be portraying the role of Andy Hodges in today's case.
Thank you.
Good morning, Your Honor, members of the jury. My name is Eloise Campbell, and I'll be portraying the role of Sam Maddox in today's case.
Thank you. And do we have any other witnesses for the defense then?
No, Your Honor, we're ready to proceed with pretrial matters. Would you like the state to go first or the defense?
I would, thank you.
Yes, Your Honor.
Your Honor, we have a few pretrial matters we'd like to attend to.
That's fine, whenever you're
First-
ready.
All right. First, what are your preferences on approaching opposing counsel, the witness, and the bench?
You can do that at the time. You do not need to seek special permission in order to do so.
Yes, Your Honor. And do we have the freedom to move about the law of the court?
You do?
And what are your preferences on expert witnesses? Would you rather have us formally tender them or simply lay foundation?
That will not be necessary as far as formal tender.
Yes, Your Honor. And finally, may we presume that all evidence arguments are made outside the presence of the jury?
Repeat that, please.
Is it safe to presume that all evidence arguments in today's case are made outside the presence of the jury?
That's correct.
And finally, would you like a copy of the case law in the state of Utopia as well as the rules of competition?
I do believe that I have both of those matters in my trial notebook. Thank you.
And then with that, the state is ready to proceed.
Thank you. And let's hear from the defense then as far as pretrial matters.
Yes, Your Honor. First, what's the court's preference on publishing or tendering documents after an examination is complete? As we will be offering courtesy copies to the bench, would you like us to publish them once we're done with the direct and cross-examination, or tender those documents to the bench as well?
You can go ahead and publish them at the time.
Yes, Your Honor. Furthermore, we'd like to bring to the court's attention Rule 4.9 of the Rules of Competition, in which witnesses in today's case are not sequestered, therefore are present for the testimony of all other witnesses.
That's fine.
And finally, Your Honor, what is the court's preference for swearing in witnesses? Would you like us to assume they've been collectively sworn in, or would you like to swear witnesses in individually before they take the stand?
I'll go ahead and swear them in individually. Thank you.
Yes, Your Honor, and with that, the defense is ready to proceed.
Thank you very much. All right. All right, well, I believe in getting started then with the formal presentation of the case. Our first order of business will be the opening statements by each side, and so at this time then, is the prosecution ready to proceed?
Yes, Your Honor.
May I proceed, Your Honor?
You may.
Your Honor, opposing counsel, members of the jury, may it please the court. In order to stop a criminal, he became one. Lee Hayes steps out into the alleyway beside Paradise Pub. She plans to speak with her cousin Orson, but quickly realizes that they are not alone. A person stands directly across from her cousin, placing their right hand on the alley wall, while raising their left arm, pointing a large handgun directly at Orson. The last words Orson hears are, "It's time you get what's coming to you. No more getting away with stuff." The person then fires several shots directly at Orson, then runs away in an odd, jerky manner. Orson dies in the alleyway that night. Lee Hayes stands silently in the corner of the alleyway, witnessing the entire crime. All she can do is call 911. Utopia City Police arrive just a few minutes later. Unable to save Orson's life, they must move on to the grim task of collecting evidence. The lead CSI investigator, Chris Vincent, will detail for you how everything he found pointed to a shocking but inescapable conclusion. The shooter was a fellow law enforcement officer, Detective Quinn Penner. Detective Penner's fingerprint was found on the same alley wall where the shooter placed their hand, and his DNA was found both on a dropped cigarette pack and under the victim's fingernails. Now, why would a fellow law enforcement officer who swore an oath to protect citizens from criminals suddenly become one? Witness after witness today will testify to the long history of conflict between the defendant and the victim. The defendant was convinced that Orson had escaped justice more than once. Most recently, after an attempted bank robbery that the defendant personally witnessed. Minutes into the investigation of the bank robbery, the defendant insisted upon participating, even over the objections of the police chief, who saw that the defendant had a conflict of interest as an eyewitness. First, the police chief sent him home, then put him on administrative leave, but the defendant wouldn't take no for an answer. He then withheld evidence that he had acquired from the scene, a cell phone that Orson Hayes had dropped during the bank robbery. Chris Vincent will detail text messages that were on this phone, showing that Orson would be at Paradise Pub the very next evening. Now, the defendant didn't share this information with his colleagues. He instead used it to devise his own alternative sentencing plan. As judge, jury, and execution. Ms. Jamie Spalding, a close friend of the defendant, will explain how she and the defendant were at a bar that evening when the defendant suddenly left and only returned 25 minutes later, sweaty and out of breath like he had just been on a run. Ms. Spalding learned of Orson Hayes' death the next day in the news. She knew Orson as one of the perps that the defendant always complained about getting away with things one too many times. She tried to ignore the idea that her close friend could be involved in this. But the truth was inescapable. The defendant, an accomplished runner, could have easily ran to Paradise Pub and back in that 25-minute break. Ms. Spaulding's fears were confirmed when the defendant bragged that it's always great when a perp gets what's coming to them, even if it doesn't happen in a court of law. Members of the jury, in order to stop a criminal, he became one. By the end of today's trial, it will be clear beyond a reasonable doubt that the defendant purposely shot and killed Orson Hayes. That is why my co-counsel, Everett Parkinol, will come before you and ask that you find Quinn Penner guilty of the murder of Orson Hayes. Thank you.
Thank you, counsel. Defense ready to proceed?
Yes, Your Honor. May I proceed? May it please the court, opposing counsel, members of the jury. This is Detective Quinn Penner. He has dedicated himself to upholding the law for over a decade. He is not a killer. The state just came before you and claimed that on the night of May 25th, Detective Penner left his friend at a local bar in order to run nearly a mile to shoot and kill Orson Hayes before returning to this same bar, all within the span of just 15 minutes. The problem with this claim is that the state is asking you to put on blinders to believe speculation over fact. In fact, what the state failed to mention is that Orson Hayes owed a significant amount of money to local gang members. Money they intended to collect on the night of May 25th. Now, the prosecution has the burden of proof in today's case. This burden is the highest in our legal system. They must prove beyond a reasonable doubt that Detective Quinn Penner shot and killed Orson Hayes, purposefully and knowingly. However, due to the evidence in today's case, the state will not be able to meet this lofty burden. Now, we as the defense are not compelled to call any witnesses or provide any evidence, but we will. Today, we will call 3 witnesses who will take the blinders off of the state story. First, we will hear from Staff Sergeant Andy Hodges, who worked alongside Detective Penner for years and was there the night the murder occurred. Staff Sergeant Hodges will testify that the person fleeing the scene ran in a distinctly different manner than Detective Quinn Penner. Staff Sergeant Hodges will testify that neither Lee Hayes nor Orson Hayes were able to identify the shooter immediately after the incident. In fact, it wasn't until the next day when talking to Officer Cochran, an officer noticeably jealous of Quinn Penner, that Lee Hayes was even able to identify the detective. Next, we'll hear from Sam Maddox, an employee at a local zoo. Sam Maddox will tell you how she hid behind a tree and listened as a man told Orson, "You owe me 50 grand for the drugs you were supposed to sell." Sam Maddox will go on to say that the man told Orson, "You have until May 25th, and not a day later." May 25th, the night Orson Hayes was murdered. Finally, we'll hear from Detective Quinn Penner himself. Detective Penner is not obligated to testify today, but he will. Detective Penner will get on this witness stand, look you in the eye, and he will tell you the truth. He will tell you that he did not kill Orson Hayes. Members of the jury, this case is simple. Throughout the course of today's trial, it is imperative that you separate speculation from fact. What you will find is that in so swiftly accusing Detective Pinner, the state put on blinders and failed to gather all relevant information, which is why at the end of today's trial, my co-counsel, Ms. Sydney Skaggs, will come before you and ask that you take off these blinders by finding Detective Quinn Pinner not guilty, as it is the only verdict that the facts compel, the law requires, and justice demands. Thank you.
Thank you, counsel. Will the prosecution call their first witness, please?
Yes, Your Honor. The state calls Ms. Lee Hayes to the stand.
Step forward, please, to be sworn. You may go ahead and approach the stand. Raise your right hand, please. Do you solemnly swear that the testimony you are about to give will be the truth according to the rules of the mock trial competition?
Yes, ma'am.
Please be seated. You may proceed.
Please introduce yourself to the members of the jury.
My name's Lee Hayes.
Tell us about yourselves.
There's not much to say, really. My parents took off when I was younger, so I was basically raised by my auntie and my uncle, and my cousin Austin. He was like a big brother to me, you know. He always protected me and provided for me. I know Austin made some mistakes, but I think at heart, he was a good guy.
Why do you say Orson would always protect and provide for you?
Well, in school, kids would always bully me, you know. When they found out my parents abandoned me, they all laughed and called me Asian Orphan Annie. Orson would always go and try to beat him up for it, and I tried to get him not to worry, but even throughout college, Orson showed me he cared. Whenever I needed money for tuition, textbooks, whatever, Orson always had it. But looking back at it now, though, I should have never accepted that money.
Why do you say, looking back on it, you never should have accepted that money?
Well, I found out later on that Orson was selling drugs. And it was mostly just pot to college students, but I was still shocked.
And what did you do once you learned that Orson was selling drugs?
Well, at first I was horrified. But then I found out pretty fast that it's hard for people like us to get a job in Utopia, even with a college degree. So Orson offered to set me up in the family business. It turns out I'm pretty lousy at selling drugs. But Orson still had pity on me. He let me earn my keep by running errands for him, driving him around, things like that, just till I could get back on my feet.
And were you running errands for Orson on May 24th of 2019?
May 24th? Yeah. Orson had me driving to this bank downtown, parked the car across the street, and I thought he was making a quick deposit or something. And while I waited, well, that's when I saw him.
Ms. Hayes, who did you see?
I saw Detective Pinner, who's over there in the green tie.
Your Honor, let the record reflect that the witness has correctly identified the defendant.
The record does so reflect.
Were you finished?
Right. So Pinner walked into the bank shortly after Orson did, and then I heard gunshots coming out from inside. And then Orson was booking it out of the bank with Pinner hot on his heels. He jumped in the car, and so I floored it. And Pinner started running after us, but it was weird.
Why do you say it was weird?
I mean, he was so fast. I mean, it was like straight out of the movies or something. But he was running in this odd, jerky manner. I'll never be able to forget the way Pinner runs.
And was the defendant able to catch you running in this odd, jerky manner?
No. He was fast, but he was no Usain Bolt. Orson and I got away, and I dropped him off, and I ditched the car. When I got home, though, I discovered that there was a college student at the bank who had been shot and was in critical condition. I was horrified, so I considered turning in Orson over to the police.
And Ms. Hayes, did you turn Orson over to the police?
No, I needed to hear Orson's side of the story first. It just didn't sound like something he'd do. And right as I was about to call him, I got a call from a number I didn't recognize.
Who was on the phone?
It was Orson. Apparently he dropped his phone during the scuffle at the bank and he had to get one of those prepaid phones. Anyways, he said he planned to skip town and to meet him at this...
Objection, Your Honor, this testimony is getting into hearsay, which pursuant to Rule 802 is inadmissible in court.
May I respond?
You may.
Your Honor, pursuant to Rule 8033, this statement goes to Orson Hayes' plan, motive, or intent, as it was his intent or plan to skip town following this bank robbery.
Overruled.
Yes, Your Honor.
Were you finished?
Right, so Orson said he planned to skip town, and he told me to meet him at this bar downtown called Paradise Pub.
And what happened once you got to this bar?
When I got there, the playoffs were on. It was the Thunderbolts against the Heat. But the whole night was just surreal for me. I mean, Orson and I sat in this cramped little booth, not even talking to each other. And then the Utopia Thunderbolts lost. And Orson needed to go outside to get some fresh air, but he didn't go out the front door. He went out this side door to the back alley.
And Miss Hayes, what did you do once Orson went out to the side door, to the back alley?
Well, I followed him, of course. I mean, I was worried about Orson. Plus, we still needed to talk about what had happened earlier. But when I got to that alleyway, Orson and we weren't alone.
Miss Hayes, who was with you in that alleyway?
There was a person who was the same exact height and build as Penna right over there, and they had their right hand up against the alley wall, and their left hand extended holding a gun pointed right at Orson. And Orson, he begged for mercy.
And how did the shooter respond to Orson's pleas for mercy?
I remember what he says, because it was so cold. He says, "You brought this on yourself. Now it's time you get what's coming to you. No more getting away with stuff. I'm going to make an example out of you." And Orson tried to defend himself. You know, he lunged for the weapon, but he was too late.
Miss Hayes, why do you say it was too late?
He shot Orson. And Orson fell to the ground. And the shooter just ran away like it was nothing, and it was in that same odd, jerky manner from the day before at the bank. I'll never forget the way Penna runs.
And Miss Hayes, did you notice anything else about the shooter as they ran away?
Other than the odd, jerky run? Yeah. There was something that fell out of their pocket as they ran away, and the police later found a cigarette pack in the same exact spot.
Miss Hayes, what did you do after the shooter fled the scene of the crime?
I cried for help, and a security guard from the bar across the street came over. They called the ambulances, but they were too late too. Orson died on the way to the hospital, and I just sat there. I couldn't think. I couldn't talk. I knew I needed to call my auntie, tell her what had happened, but I didn't even know what to say. I'm her only baby now.
Thank you, Miss Hayes. Your Honor, I have no further questions at this time.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Now, Miss Hayes, I understand this is going to be difficult, but I'm going to have to ask you some questions about your cousin. Is that all right?
Yeah, that's okay.
Now, I'd like to discuss the day of May 24th. You were with your cousin Orson that day.
Yeah, he had me drive him to the bank downtown like I said earlier, but I really thought he was just making a quick deposit.
That's right, you thought he was making a quick deposit. So, you weren't aware that he was going to rob this bank, correct?
No, not when I went into it that day at all, no.
But, Miss Hayes, you'd also agree with me that you were given a plea deal regarding this interaction, correct?
Yes, I was given a plea deal.
And that was in exchange for your testimony here today against Detective Penner?
Yeah, but that's not why I'm here today. I'm here so that my cousin Orson can get justice.
But you'd recognize a copy of this plea deal if I were to show it to you?
Of course, ma'am.
Your Honor, may the record reflect I am now approaching opposing counsel with what has been previously marked as Exhibit 1. This is the tabulation of the witness. Courtesy copy, Your Honor.
Please,
May I
thank you.
approach the bench?
You may.
And may I approach the witness?
You may.
No. Ms. Hayes, I've just handed you a copy of the state's offer of plea of guilty. It's a fair and accurate copy, correct?
Yes, I believe so.
And has not been changed or altered in any way?
Not from what I can see.
And that is your signature on the bottom of the page?
Yes, ma'am, it is.
And you'd agree with me that you signed this plea deal immediately after it was offered to you?
Yeah, I signed it.
Your Honor, this defense now moves to the introduction of Exhibit 1 into evidence.
Any objection?
Yes, Your Honor. This document is hearsay.
May I respond, Your Honor?
You may.
Pursuant to Rule 8036, this is a document of regularly conducted business activity. We've laid the foundation that all of the 5 steps of the foundation that was required to admit this as a business or a regularly conducted activity, and therefore would be an exception to hearsay.
May I respond?
You may.
Under 8036, it requires that this document must be shown by a custodian of this document. As the custodian of this document is not present in court today, it does not meet all the qualifications it needs to be entered under 8036.
May I respond, Your Honor?
You may.
The statements made on this document were adopted by the witness after signing it. Additionally, this would also fall under the exception 8035, recorded recollection. Pursuant to Stipulation 2, all statements within documents or exhibits in today's case are authentic, and witnesses must attest to them. And as witnesses' testimony is contradictory to testimony they've previously given within the exhibit, it would also meet that qualification under 8035, additionally under 8036.
May I respond?
You may.
Again, under 8036, it does not meet this exception, as the custodian of this document is not here in court today. Under 8035, I believe the witness has already given her statement as to what happened in this plea deal, and I don't see the reason we need to bring this plea deal itself into court today when she can already testify to its contents.
I agree. The document will be excluded. The objection is sustained. You can question the witness about it.
Yes, Your Honor.
Yes, Your Honor.
Now, Ms. Hayes, you testified that you didn't know the intentions of your cousin Orson Hayes that day, but you'd also agree with me that in signing a plea deal, you admitted to knowing the intentions of your cousin, correct?
Going into it that day, like I said earlier, I really thought he was making a quick deposit. But yeah, when Orson ran out of the bank with the police on his heels, I did connect the dots.
So that's a yes, you were aware of the intentions of your cousin?
Yeah, especially after I saw it on the news.
Furthermore, in exchange for your testimony here today, you're being offered a reduced sentence for the charges you received for this action, correct, for this encounter?
I mean, maybe, but again, that's not why I'm here. I'm here so that my cousin can get justice for his murder.
And you said maybe, but in fact it is true. You're receiving a reduced sentence in exchange for this plea deal.
Yeah, but again, I'm here for Orson. Nobody deserves to be shot down like a dog in an alleyway.
And I understand that, but prior to this plea deal, you were looking at serving almost 9 years in prison, correct?
That sounds about right, ma'am.
And after you agreed to testify against Detective Penner in court today, you're receiving a reduced sentence of 10 to 13 months. Isn't that right?
Again, that sounds about right, but it's not why I'm here today.
Now I'd like to talk about the day of May 25th. You met Orson at Paradise Pub.
Yeah, on May 25th, Orson and I met up at Paradise Pub.
And you were watching the NBA playoff game, correct?
Yeah, we always like to watch the Utopia Thunderbolts play. We're big basketball fans.
But you had actually suspected that your cousin had a lot of money riding on this game.
You know, that's what I thought at the time, but I couldn't really be sure.
Now you say you couldn't be sure, but Orson later confided into you that he had a lot of money riding on this game, correct?
Again, that's what I thought, but I can't be completely positive about it all. Orson didn't keep me in on the financials.
Well, you say you can't be completely positive, but Orson did specifically tell you that he had a lot of money riding on this game, correct?
Again, it's what I was suspecting, but
Now, after the game proceeded, Orson seemed extremely stressed out, correct?
He seemed a bit more stressed than normal, but everybody in the bar was that night. It was a really tight game, actually.
And after the game was over, Orson told you that he was worried that he wouldn't have the money to pay back his drug bosses and that they were going to make an example out of him, correct?
You know, that's what Orson says to me, but I really wasn't kept in all the inner workings of Orson's job.
But that's yes, he was worried that his drug bosses were going to make an example out of him.
Objection, Your Honor. The statement that opposing counsel is talking about is a hearsay statement.
May I respond, Your Honor?
You may.
Pursuant to Rule 803.3, this goes, 803.3, then existing mental, emotional, or physical condition. It goes to the declarant's emotional condition, in this case Orson Hayes, his fear that his drug bosses were going to hurt him as a result of him not being able to pay them back. Therefore, it would qualify as a hearsay exception under that rule.
Objection is overruled. You may proceed.
Yes, Your Honor. So again, Orson confided to you that he was worried his drug bosses were going to make an example out of him if he wasn't able to pay them back, correct?
Yeah, like I said, that's what he says to me.
And immediately after he made this statement, he exited the bar.
Yeah, I thought he was getting fresh air, but he went out this side door.
And you followed him.
Of course, I was worried about Orson, you know, I still cared.
And when you went outside, you heard a voice tell Orson, "I'm going to make an example out of you," correct?
Yeah, that was one of the many things that the person said in that alley.
And the voice, the person that said that statement was holding a gun to Orson, correct?
Yeah, with the left hand, and the right hand was on the alley wall.
And you'd agree with me that during this encounter, you were over 20 feet away from your cousin and the unknown assailant, correct?
Yeah, it was 20 feet away, but it was a little closer than that. But I have 20/20 vision, so seeing that far is not a problem at all for me.
But it was quite dark outside.
It was dark, but the moon was full, so once your eyes adjusted, you could see just fine. And I could see Penna's height and build.
Well, you say you could see just fine, but you'd admit to this jury that you couldn't see the race of the shooter, correct?
Maybe not their race, but I could see their height and their build, and it was distinctively Penna's.
And you couldn't see the gender of the shooter, correct?
Maybe not their gender, but as they ran away, it was in the same odd, jerky way that Penner had run the day before at the bank.
And you couldn't identify any distinctive facial features to be able to identify the shooter, correct?
Maybe not, but again, the build, the height, the run, it all matched Penner's perfectly.
But this was all because you couldn't see that night, correct?
I could see that night, but I wasn't able to see the gender. That's all.
In fact, it was so dark outside, you'd admit to this jury that you're not 100% certain that in fact it was Detective Penner in that alleyway that night, correct?
Maybe not 100% sure, but I'm 100% sure that the height, the build, and the run match Penner's exactly.
But that's a no. You're not 100% sure that it was Detective Penner in the alley that night.
Yeah, that's a no.
No further questions at this time, Your Honor.
Thank you.
May I retrieve the exhibit from the witness?
You may.
May I approach the witness?
Redirect.
Thank you.
Very briefly, Your Honor.
Okay.
May I proceed? Opposing counsel just spoke about a plea deal. Did you sign this plea deal before or after you had identified Detective Penner as the shooter?
I signed it well after I had identified Penner as the shooter.
Thank you, Ms. Hayes. Your Honor, I have no further questions.
Thank you. Any recross?
Just briefly on that point. Now, you identified Detective Penner before the plea deal, but you didn't agree to testify in court today until after you were offered this plea deal, correct?
I planned to testify.
But you did not agree to testify against Detective Penner until after you were offered this plea deal, correct?
Well, I wasn't sure if I would be allowed to testify, to be honest.
I'm sorry, is that a yes or a no?
Sorry, could you re-ask the question?
Of course. You didn't agree to testify until after you were offered a plea deal, correct?
No, I didn't agree to testify because I wasn't really sure if I was going to be allowed to testify.
No further questions at this time, Your Honor.
Thank you. The witness may step down. Call your next witness, please.
Yes, Your Honor. At this time, the state calls Mr. Chris Vincent to the stand.
Raise your right hand, please. Do you solemnly swear that the testimony you are about to give will be the truth according to the rules of the mock trial competition?
Yes, I do.
You may be seated.
May I proceed? Please introduce yourself to the members of the jury.
Good morning. My name is Chris Vincent.
And what do you do for a living?
I was an assistant forensic specialist at the Rome City Police Department. In March of last year, however, I moved to Utopia, and I joined the Utopia City Police Department as a forensic specialist.
Are you published in your field?
Yes, I've published many articles regarding ballistic analysis and fingerprint evaluation. I also wrote an article in the Journal of Forensic Sciences.
And have you been recognized in your field?
I'm currently a member of Delta Delta Epsilon, a Forensics Honor Society. I also received the Gibbs Outstanding Forensic Science Award by the NCIAI for my achievements in criminal identification.
Now, how are you involved in today's case?
I was the lead forensic specialist for today's case involving the murder of Orson Hayes.
Were you able to reach a conclusion in this case?
Yes, I was.
Did you have sufficient facts and data when reaching this conclusion?
Yes, I received a large quantity of evidence from the crime scene investigators. There are ultimately three main types of analysis that I used to come to my conclusion: a DNA analysis, a latent fingerprint identification, and a cell phone data recovery.
First, let's talk about your DNA analysis. What DNA samples did you analyze in this case?
I was given 2 DNA samples to review in today's case. The first was taken from a swab from underneath the victim's fingernail. The second was from a cigarette pack where the fleeing criminal dropped the item.
And what techniques did you use to determine the identity of the DNA found on the evidence?
I conducted a short tandem repeat analysis, also known as an STR analysis. This form of testing has been subject to peer review, has a well understood error rate, and is really the gold standard when it comes to identifying DNA samples.
And what is an STR analysis?
During an STR analysis, we examine short sequences of DNA at 15 locations on the DNA double helix. At these 15 locations, there are alleles, or genetic markers. We can then use this information to generate a graph called an electropherogram that plots these alleles, as peaks on the graph. Comparing an electropherogram created from an unknown sample of DNA and comparing it to an electropherogram based off a known sample of DNA can tell us the probability that the 2 DNA samples match.
And what were the results of your analysis of the DNA found under the victim's fingernails?
As I expected, the DNA found underneath the victim's fingernail was a mixture of 2 individuals' DNA, the victim himself and an unknown individual. However, when I compared the electropherogram based off the DNA taken from underneath the victim's fingernail and compared it to the electropherogram based off DNA taken from the defendant, for 13 of the 15 alleles, they were identical. The other 2 were missing, as happens during the amplification process.
And what were you able to conclude from your STR analysis of the victim's fingernail swab?
First, I was able to conclude that the probability of the DNA found underneath the victim's fingernail belonged to anyone other than Detective Penner is approximately 1 in 1 billion. Second, the most likely explanation for this occurrence was that the defendant and victim scratched each other or came into some sort of physical contact close to May 25th, 2019.
Now, what analysis did you perform on the cigarette pack found at the scene where the fleeing criminal dropped an item?
I tested that cigarette pack for DNA, and results came back indicating that it matched that of Detective Penner. From this information, I was able to conclude that the defendant touched that cigarette pack in the alleyway. Additionally, since the DNA hadn't degenerated significantly, the defendant must have touched the pack sometime close to May 25th, 2019.
Was there any other evidence that led you to determine that the defendant was in the vicinity of the crime scene?
Yes, in fact, detectives also lifted a clear latent fingerprint off the alley wall where Lee Hayes stated she saw the shooter. I then performed a latent fingerprint identification comparing this fingerprint to known fingerprints taken from the defendant.
How did you perform this latent fingerprint identification?
Fingerprint identification involves an examiner comparing the characteristics and structures of the ridge patterns of a fingerprint to identify specific minutiae or details. We can then compare the minutiae found on an unknown print and compare it to the minutiae found on a known fingerprint to calculate the number of minutiae point matches between the 2 fingerprints. It's a standard technique used in Utopia and is considered reliable if an examiner finds a minimum number of minutia point matches.
And what were the results of your analysis?
I was able to find 12 minutia point matches between the fingerprints on the alley wall and known fingerprints taken from the defendant. In Utopia, 12 such minutia point matches allows me to conclude that the two fingerprints are indeed a match. Therefore, I was able to conclude that the defendant touched the alley wall within a short time span surrounding the murder.
Now, let's talk about the cell phone data you recovered. What cell phone data were you provided in this case?
I analyzed the cell phone the victim dropped during his attempted bank robbery on May 24th. Specifically, I noted an irregularity in the chain of custody of the phone.
What was the irregularity in the chain of custody of the phone?
Well, all other evidence came in a standard evidence box delivered directly from the crime scene. However, this particular piece of evidence wasn't included. Instead, the defendant recovered the cell phone on the 24th, but failed to submit or log the evidence that day. I was later given the cell phone by Officer Concord during my investigation.
What cell phone data were you able to recover if this phone was eventually returned to the department?
The cell phone contained a series of messages, most of which were unremarkable to my investigation, but there was one message of importance.
Would you recognize a copy of the document containing these text messages?
I would.
Your Honor, at this time, let the record reflect them approaching opposing counsel with what has been previously marked as Exhibit 9. Let the record reflect them approaching the witness. Your Honor, like a courtesy copy.
Thank you.
Mr. Vinson, do you recognize this document?
Yes, it's a copy of a message log found on the cell phone the victim dropped during his attempted bank robbery.
And is this a fair and accurate depiction of this document?
It appears so.
Your Honor, at this time, the state moves to enter Exhibit 9 into evidence.
Any objection?
No, Your Honor.
Let it be received. You may proceed.
May I publish the Exhibit 9 to the jury?
You may.
Now, what was the message of importance on this document?
It's the message here at the very top. It's sent from an unknown individual to Orson Hayes. States, "Meet me at Paradise Pub on Saturday, 12:45. The message had been deleted, but I was able to recover it. I'll admit, I don't know exactly when the message was deleted, but it is highly plausible that the defendant did have access to this information and would therefore know where to find Orson Hayes on the 25th.
Objection, Your Honor. This is speculative.
Response?
Your Honor, expert witnesses are allowed to answer hypotheticals, and in this case, based on all the evidence that Mr. Vinson has collected, he's allowed to make his opinion that the defendant did do this.
May I respond, Your Honor?
You may.
Your Honor, while I agree that this forensic investigator can answer questions to hypotheticals about DNA evidence or fingerprint analysis, they cannot go into the text messages or other aspects of the investigation, such as whether Detective Quinn Pinner may have had access to these text messages.
Your Honor, may I respond?
You may.
Mr. Vinson has only said that it is plausible within the time span that that the defendant had this phone in his possession, so it is plausible that he could have looked at these text messages.
I'll allow it. He did indicate that this was, the examination of the phone was part of his forensic analysis being involved in the case. I'll allow it.
Yes,
Objection
Your Honor.
overruled. Thank you.
Mr. Vinson, were you finished with your answer?
No, but if you could just please repeat the question.
Now, what conclusions regarding the murder of Orson Hayes were you able to reach after reviewing all of the evidence that you analyzed in this case?
Cell phone data demonstrates that the defendant did have access to information that indicated the likely whereabouts of Orson Hayes that evening. DNA analysis indicates that a violent interaction between the defendant and victim took place close to May 25th, 2019. Additionally, a survey of the crime scene indicates that the defendant was in fact near the crime scene close to the time the shooting took place. When considered as a whole, the evidence all leads me to conclude that the defendant committed the murder of Orson Hayes.
Thank you. Your Honor, no further questions.
Thank you.
May I retrieve the document and publish it to the jury?
Are you talking about Exhibit 9?
Yes, Exhibit 9.
I believe you did publish that to the jury.
Oh, may I retrieve from the witness stand?
You may.
Your Honor?
Mhm. Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Good morning. I'd like to begin by discussing your investigation of today's case. As you mentioned on your direct, you examined 2 cell phones. Is that right?
Yes, I examined the cell phone found on the victim's body after his death and the cell phone the victim dropped during his attempted bank robbery.
And so you're familiar with the text conversations recovered from both of these cell phones?
I am.
And you'd recognize copies of each of them if I were to show them to you here today?
I would, yes.
Let the record reflect that I'm now showing opposing counsel what has been previously marked as Exhibit 2 as well as Exhibit 9. Courtesy copy of Exhibit 2, Your Honor.
Yes, please.
May I approach the bench?
You may.
May I approach the witness?
You may.
Exhibit 2. Now, Exhibit 2 is a text conversation recovered from a cell phone from the victim's person. Is that right?
That's correct, yes.
And it's fair and accurate?
Yes.
It hasn't been changed or altered in any way?
Not to my knowledge.
Your Honor, at this time, defense now moves for the introduction of Exhibit 2 into evidence.
Any objection?
No, Your Honor.
Let it be received.
Now, I'd like to take these cell phones one at a time. Specifically, I'd like to focus on the text you mentioned on your direct. This text reads, "Meet me at Paradise Pub on Saturday at 1:45. Bring what you owe me or you'll be sorry." Did I read that correctly?
You did, yes.
Now, that text came from an unknown number. Is that right?
Yes, and it was sent from an unknown individual to Orson Hayes.
Mm-hmm. And Paradise Pub is the location where Orson Hayes was murdered?
It is near the location, but not the exact location, no.
Excuse me, the alley behind Paradise Pub is where Orson Hayes was murdered. Is that right?
That's correct, yes.
And Saturday was the day Orson Hayes was murdered?
Yes, Saturday was May 25th.
And 1:45 is the exact time Orson Hayes was murdered.
Well, I can't say for sure what the exact time was, but it was near 11:45.
Now, I'd like to look at this second text message conversation. Orson Hayes texted this unknown number, "I'll have the money this time. I just need an hour." Did I read that correctly?
You did, yes.
The unknown number replied to Orson, "You're out of time. You're going to regret it if I have to hunt you down." Did I read that right?
Yes.
And at 11:41 p.m., the unknown number again texted Orson, "I'm almost there." Is that right?
That's correct.
Now, I'd like to move on to your conclusions in today's case. Some of the conclusions you made on direct related to DNA evidence. Is that right?
They were.
However, you cannot say, in your professional opinion, that a juror can rely solely on DNA evidence alone when convicting someone of a crime, can you?
No, they cannot rely solely upon the DNA. That's why I conducted a fingerprint analysis, examined these cell phones, and also did a ballistic analysis.
But that's a no. DNA evidence alone cannot be used to convict someone of a crime, especially when other factors such as cross-contamination may be present.
Well, like I said, DNA itself solely cannot be used to convict a suspect. However, cross-contamination in this circumstances was highly unlikely.
However, you cannot be 100% certain that cross-contamination didn't occur.
I can't be 100% certain, but the crime scene investigators at Utopia are very well trained and very careful to present any such problems. I have not been made aware of any problems during my time period.
Now, you concluded that Orson Hayes must have scratched Detective Quinn Pinner because you found DNA evidence under Orson Hayes' fingernails. Is that right?
Usually that's the circumstances, yes.
However, you can't say for certain when this altercation would have occurred.
I can't say exactly when, but it had to be close to the time of the shooting.
Exactly. Hypothetically, it could have occurred the day before during a bank robbery.
It could have been, but that would have been highly unlikely. DNA is a very delicate biological molecule. Simply washing your hands, touching dirty surfaces, can contaminate the DNA underneath the victim's fingernail. Therefore, if it had been left there a full day prior, it had been highly unlikely that we would have gotten such a clear read.
But that's a yes. It is possible that the altercation could have occurred an entire day before the murder.
It is a possibility, but a highly unlikely one.
And you also concluded that the defendant, Quinn Pinner, was in the vicinity of the murder due to DNA evidence found on a cigarette pack.
Yes, and there's also his fingerprints on the alley wall.
However, you cannot be 100% certain when the cigarette pack would have been dropped, can you?
I can't give the exact minute, no.
Hypothetically, it could have been a day before when Detective Pinner was smoking in that alley.
It could have been, but this was a DNA pack in which the DNA had not degenerated significantly. This means that the DNA had been placed there sometime close to May 25th, 2019.
But that's a yes. It could have been dropped or placed there the day before.
That is a possibility.
Now, moving on, you didn't examine all of the evidence provided to you in this case, did you?
I examined the evidence in today's case, yes.
But Investigator Vincent, dozens of cigarettes, aside from the cigarette pack, were found in the alley, weren't they?
Yes, but most of those cigarettes had been stomped on. It was a well-traveled alleyway, and it would have been inconclusive to get any sort of evidence off of it.
But you didn't even run tests on these cigarettes, did you?
No, as I said, there's no need to. The quality of these cigarettes were very poor.
But that's a no. You didn't run tests on the dozens of other cigarettes found in the alley, did you?
I did not.
And you had access to a CODIS DNA database, is that right?
I do, yes.
And you would agree that this CODIS DNA database would have given you access to the ability to compare the DNA in the alleyway against local known gang members, wouldn't it?
It does give me the ability to do so, that's correct.
However, you chose not to use this database, didn't you?
No, I did not. Like I said, the cigarettes found in this alleyway were in very bad condition. Highly unlikely that we would have gotten any conclusive evidence off of it.
So that's a no. You did not test this DNA in the CODIS database.
No, I did not.
Thank you, Your Honor. No further questions at this time. At this time, may I approach the witness to publish Exhibit 2 to the jury and retrieve Exhibit 9?
You may. Any redirect?
Briefly, Your Honor.
All right.
Mr. Vincent, why do you believe that all this evidence was placed on May 25th, 2019?
Like I said before, the DNA found underneath the victim's fingernail, DNA is a very delicate molecule. Therefore, it's highly unlikely it could have been left there a full day prior. The DNA on the cigarette pack hadn't degenerated significantly, indicating it had to be close to the time frame of May 25th. And the fingerprint on the alley wall was a clear, latent fingerprint in an alley that was well-traveled and exposed to natural elements. It's highly unlikely that we would have gotten such a clear read if this fingerprint had been left there even a day prior.
We heard on cross-examination that an unknown individual scheduled a meeting with Orson Hayes. Is there any physical evidence that would indicate that this meeting ever took place?
No, there's no physical evidence implicating that a meeting took place. All the physical evidence I reviewed pointed to only one individual, Detective Penner.
Thank you, Mr. Vincent. Your Honor, no further questions.
Any recross?
Briefly, Your Honor. For clarification, it is possible that the DNA evidence on the cigarette pack could have been placed there the day before, correct?
It is a possibility, but a remote one.
And it is possible that the DNA under Orson's fingernails could have happened from an altercation the day before, correct?
Yes, it is a possibility.
Thank you, Your Honor. No further questions at this time.
Thank you. The witness may step down. Would the prosecution call their next witness, please?
Yes, Your Honor. The state calls Ms. Jamie Spalding to the stand.
Raise your right hand, please. Do you solemnly swear that the testimony you are about to give will be the truth according to the rules of the mock trial competition?
Yes, Your Honor.
You may be seated.
May I proceed?
You may.
Please introduce yourself to the jury.
My name is Jamie Spalding.
What do you do for a living?
Well, I run and operate my own gym, Jamie's Jungle Gym. We get you feeling in great shape and feeling like a superhero. I have a diverse range of clients, from little teenage boys who want to impress their girlfriends to even law enforcement, like Quinn Penner.
Could you tell us a little bit more about your relationship with Quinn Penner?
Sure. I first met Quinn in 2017 when he joined my gym. We hit it off immediately. Not only was he a great athlete, but he was really kind. Last year, he even offered for some extra police patrol around my gym when there was some concert going on at a bar. He was always trying to help the gym out, and I appreciate it. One of the most dedicated cops you'll probably ever meet.
Now, was the defendant at your gym on May 25th, 2019?
Quinn typically worked out on Saturdays, so yes, he was there. We had plans to go watch the NBA playoff games after our workout. It was gonna be a great night. But he seemed so on the edge and jittery, so I asked him what was wrong.
What was the defendant's explanation for seeming so on edge and jittery on a Saturday evening?
He just said, "I'm just tired of perps always getting away with stuff." He was always going on about stuff like that, catching perps, keeping scum off the street. He wouldn't tell me anything else, so I let it drop. We then left the gym, probably around 9:30.
Where did you go once you left the gym?
We went to Rubicon Sports Bar. We typically go there after our workouts. But this time was just different.
How did this time seem different?
Well, Quinn insisted on driving, which was weird. We usually always walk to the bar. It's only a mile away and parking can be such a nightmare. But Quinn insisted. And he wouldn't even let me change out of my workout clothes.
Now, how did your evening at the bar proceed?
Well, we got there, we ordered some food and drinks, and watched the game. Then the Thunderbolts lost, and that's when Quinn decided to step out instead of watching the post-game analysis.
At what time did the defendant step out of the bar that night?
It was sometime around 11:30. He was going for a smoke break.
Where did the defendant go for the smoke break?
I don't know exactly. I just saw him go outside and go to the passenger side of his car. I assumed he was just getting some cigarettes, so I went back to watching my post-game analysis. But this just didn't seem like a normal smoke break.
Why did this not seem like a normal smoke break?
Well, Quinn was gone for a full 25 minutes. Kind of long for a smoke break, don't you think? And when he came back, he was acting all funny.
How was the defendant acting funny?
Well, Quinn was out of breath. I mean, I know smoking is bad for your lungs and all, but Quinn was never usually this out of breath from smoking, and he was all sweaty. It was a muggy night, but it wasn't that hot to where you should sweat just from standing still.
Now, how did your evening proceed from there?
We finished our drinks, and Quinn took me home around 1 a.m. I didn't think much about the odd smoke break until the next day.
Why did you think of the odd smoke break the next day?
Well, I was working out and watching the news. That's when I heard this familiar name, Orson Hayes. It really rang a bell.
Why did the name Orson Hayes ring a bell with you?
I realized Orson Hayes was one of the criminals Penner always complained about getting away with stuff one too many times. That's when I started to think about the smoke break more and more.
Why did you think of the smoke break more and more?
It just didn't make sense. I mean, 25 minutes is such a long time for a smoke break. He was out of breath and sweaty when he came back. That's when I remembered Quinn often bragged how he could run the fastest mile on the force. Quinn could have easily run to Paradise Pub.
Objection, Your Honor. Improper lay opinion. May I proffer?
You may.
This is a lay witness. I don't believe she is able to testify to the skills and experience of Quinn Penner as she is a lay witness.
Your Honor, may I respond?
You may.
My witness is not testifying to the experience of Detective Penner. She simply stated that Detective Penner could have easily ran to Paradise Pub and back in 25 minutes. We've already laid the foundation for her testimony, and it's all based on her rationally based perception. As a trainer, which Ms. Spaulding has stated, she would have observed Detective Penner in the gym, and therefore she can give this based on her rationally based perception.
May I proffer, Your Honor?
You may.
If opposing counsel is trying to say that this witness is the trainer of Detective Penner, then she would be an expert witness, and I don't believe enough foundation has been laid for her to be entered as an expert witness.
Your Honor, may I respond?
You may.
We do not need to lay or formally tender Ms. Spaulding as an expert witness. I'm only asking this on her rationally based perception. And again, as a trainer in a gym that does teach parkour, Ms. Spaulding is well aware of the skill of Detective Penner and can give this on her rationally based perception.
I'll allow it. Objection overruled.
Yes, Your Honor.
Yes, Your Honor. Would you like to continue?
Sure. Like I was saying, Quinn could have easily run to Paradise Pub and back in 25 minutes. But I didn't want to think about it. Quinn was my friend. There was no way he could possibly... I don't know. I didn't want to think about it, but I had to when he came back to the gym.
What happened the next time the defendant was at your gym?
Well, he came back and he was acting much happier and calmer. I asked him why. That's when he said, "It's always great when a perp gets what's coming to them. Sometimes it's nice to see justice served, even if it doesn't happen in a court of law."
How did you respond to the defendant stating, "It's nice to see justice served, even if it doesn't happen in a court of law"?
I was speechless. I didn't know what to say. I suddenly saw him in this whole new light and decided I should come forward to tell the truth. And that's when I came to the police on my own. Quinn was supposed to catch criminals, not become one.
Thank you, Ms. Spaulding. Your Honor, I have no further questions.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Orson Hayes was murdered on May 25th around 11:45 p.m., correct?
Correct, I found that out from the news.
And weren't you with Detective Penner on that night at Rubicon Sports Bar?
I was with him that night. We were watching the NBA playoff games.
And to your memory, it was after 11:30 when Detective Penner stepped out for a smoke break.
Penner stepped out around 11:30.
And with it being around 11:30, but you not knowing a specific time, it could have been 11:40 or even 11:45.
Oh, no. I don't think it can be 11:45. I think that's way after 11:30. I know it was around 11:30.
And Ms. Spaulding, can you tell the jury the specific time he stepped out?
No, but like I said, it was around 11:30, not around 11:45.
Right. And Ms. Spalding, your memory in today's case is crucial because Detective Penner is being charged with murder. But you would admit to this jury that you suffer from short-term memory problems.
I do. It actually happened from a gymnastics accident, but that has no bearing in my memory. It only affects my driving, so it's not a big deal.
Right, so you sustained this concussion, you quit competitive gymnastics, and you sought and received the best help, but still 15 years later, a decade and a half later,
Objection, Your Honor. This is a compound question. I asked the opposing counsel to break it up so my witness can answer.
Overruled.
Yes, Your Honor.
You may proceed.
So a decade and a half later, you still suffer short-term memory problems.
I do, but like I said, it only affects my driving, so it's not a big deal.
Ms. Spalding, I'm not asking what you think it affects, I'm asking if you still suffer these problems.
It does, and I know it only affects my driving.
Right. And on the night of May 25th, when you guys were at the Rubicon Sports Bar, can you tell the jury how many alcoholic beverages you had to drink that night?
It was just a little. It wasn't much.
And can you tell the jury how many drinks were purchased on that night?
Well, between both me and the defendant, it was about 4 whiskeys and 3 beers.
So around 7 drinks, right?
Between both me and the defendant.
Right. And isn't it true that you had more to drink than Penner?
It was just a little, but it was over the course of several hours, and I had plenty to eat as well.
I'm not asking if you had anything to eat, I'm just asking you had more than Detective Penner.
Just a little.
Right, so with you having more than Detective Penner, purchasing 7 drinks, and you not being able to tell the jury the specific amount you had, you would agree with me it would be a possibility you could have had 4, 5, or even 6 alcoholic drinks the night Orson was murdered.
No, I don't believe I had that much more than him.
But you can't tell the jury the specific amount you had.
No, it was just a little though.
Right, so it still could be a possibility that it was 4, 5, or even 6, yes or no?
A very unlikely possibility.
But yes.
Yes, unlikely.
No further questions, Your Honor.
Any redirect?
Briefly, Your Honor. Now, Ms. Spalding, did the alcohol make you drunk that night or impair your testimony today?
Oh, no, not at all. I did have a little to drink, but it had no impairment of my memory of that night.
Thank you, Ms. Spalding. Your Honor, I have no further questions.
Any recross?
No, Your Honor.
All right, this witness may step down. Does the prosecution have any further witnesses?
No, Your Honor. At this time, the state rests its case in chief.
All right, very well. Given that the state has completed the presentation of its case in chief, we will go ahead and take a 5-minute recess, a bathroom break for purposes of giving everyone an opportunity to use the facilities and stretch their legs, and we'll get started in 5 minutes with the defense's case. Thank you.
Yes, sir.
Is the defense ready to proceed?
Yes, Your Honor. At this time, the defense calls Andy Hodges to the stand.
Thank you. If you would step forward, please. And raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth according to the rules of the mock trial competition?
Yes, Your Honor.
You may be seated.
May I proceed?
You may.
Good morning. Can you please introduce yourself to the judge and to the jury?
Good morning. My name is Andy Hodges.
And Ms. Hodges, are you currently employed?
Yes, I'm a staff sergeant at the Utopia City Police Department. This basically means that I train all the new recruits that come through our office.
How long have you been employed at the UCPD?
For about 22 years now.
Do you know the defendant in today's case, Detective Quinn Penner?
I do, yes. I met Penner when he was just a rookie, and I noticed he had a ton of potential. So from 2006 to 2008, I partnered with him until he was promoted to vice squad detective.
Now, I'd like to discuss the night the incident occurred. Where were you May 25th?
Well, I actually have 2 twin sons, Justin and River, that are in college right now. So in order to help them pay tuition, I was moonlighting security at Thomas's Tavern, which is an upscale pub.
Generally, where is Thomas Tavern located?
Thomas Tavern is in downtown Utopia.
So would you recognize a map of downtown Utopia if I were to show it to you?
Of course I would.
Let the record reflect that I'm now showing opposing counsel what has been previously marked as Exhibit 3. Courtesy copy, Your Honor.
Please.
May I approach the bench?
You may.
May I approach the witness?
You may.
Now, Sergeant Hodges, what is this?
This is a map of downtown Utopia.
And does it appear to be a fair and accurate copy?
It does, yes.
Has it been changed or altered in any way?
It has not, no.
Your Honor, at this time, defense now moves for the introduction of Exhibit 3 into evidence.
Any objection?
No, Your Honor.
Let it be received.
Now, Officer Hodges, can you please explain in more detail where Thomas Tavern is located?
Yes, so as you can see right here, Thomas's Tavern is labeled number 4 on the key, and it's right here.
And where is Paradise Pub located?
Paradise Pub is directly across the street, labeled number 3 on the map.
And can you please explain to the jury where this murder occurred?
It occurred in an alleyway right behind Paradise Pub.
Now, going back to the actual events of that night, what can you recall about the night of May 25th?
Well, at 11:30, a lot of disgruntled fans were coming out of the bars after an NBA game. I'm not a huge NBA fan myself, so I didn't have an issue with missing the game. But at 11:45, I checked my watch, and then I heard a scream out of fear, followed by 3 rapid gunshots.
Once you heard these gunshots, what did you do?
Well, I immediately ran over to see what all the commotion was. And as I ran over, I noticed there was someone fleeing the scene, someone on the ground who was obviously injured, and then another person bending over the body.
So you rushed to the alley to find someone on the ground with another person bending over them. How do you react?
Well, I knew I wouldn't be able to catch the person fleeing the scene, but so I ran over to the person on the ground and I tried to administer first aid. Well, first I called 911 and then I tried to administer first aid. And as I walked closer, I recognized the victim to be Orson Hayes.
Were you able to recognize who was helping Orson?
Not at first, no.
Could you eventually come to recognize who was helping Orson?
Yes, it was Lee Hayes.
Now, was Orson Hayes, immediately following the event, able to identify who shot them?
He was unable to, no.
And was Lee Hayes, immediately following the event, able to identify the shooter?
He wasn't able to either, no.
Now, based on your personal observations, did you personally notice anything unusual as the shooter was fleeing the scene?
Yes, the shooter ran in a very unusual fashion. It was distinctly different than anything I'd ever personally seen before.
Now, Sergeant Hodges, based on your personal observations, were there any similarities between the way the shooter ran and the way Detective Pinner runs?
No. I've worked with Detective Pinner for years. I was even his partner for 2 of those years. And I can say that Detective Pinner, while running in a unique fashion, it was distinctly different that night when the shooter was running away.
Now, did you have any other opportunities to talk to Lee Hayes about the incident?
Yes. After the shooting, I saw him at the hospital, and I tried to ask him if he could recognize the shooter, and he wasn't able to. So Detective Cochran and I conducted an interview the next morning.
How did this interview go?
Well, admittedly, it did not go as planned.
You say it didn't go as planned. Why is this?
Well, Detective Cochran was almost coaching Lee Hayes on the statements, kind of egging Lee Hayes on to make specific statements against Quinn Pinner.
Now, who is Officer Cochran?
Officer Cochran is just another member of the police force.
Do you know how long Officer Cochran has been on the police force?
For about 15 years, I believe.
Now, over the course of these 15 years, were you able to personally observe Officer Cochran?
Yes.
Now, let's go back to the interview in question. You mentioned that it didn't go as planned. Why exactly is this?
Well, Detective Cochran was offering up specific information about the way the detective penner runs.
Can you recall any specific questions that Officer Cochran may have posed to Lee Hayes for Lee Hayes to then confirm or deny?
Yes, the specific details about the way penner runs.
Now, Sergeant Hodges, is it standard police procedure for a police officer to offer specific statements to an eyewitness?
No, in fact, it's extremely unprofessional.
And to your knowledge, prior to this interview, were there any times in which Officer Cochran may have come in contact with Lee Hayes?
Yes, in fact, Officer Cochran was the one who drove Lee Hayes to this interview.
Now, to your knowledge, was anyone else in the car with Officer Cochran and Lee Hayes during this car ride?
No.
Thank you, Your Honor. No further questions at this time.
Cross-examination.
Your Honor, at this time, may I approach the witness to publish Exhibit 3 to the jury?
You may. Cross-examination.
May I proceed?
You may.
Now, Sergeant Hodges, I'd first like to start off by clarifying exactly what you saw on May 25th, 2019. Now, you stated on direct that you were working at Thomas's Tavern that evening, correct?
I was, yes.
And at 11:45, you heard gunshots and a scream, isn't that right?
Yes, I did, and I immediately ran over to see what all the commotion was.
That's right. And once you got there, you saw somebody running away, isn't that right?
I did, yes.
And you noticed that this person running away was running away quickly, isn't that right?
They were, yes.
And they were also running in an unusual manner, correct?
In an unusual manner, but in a way that was distinctly different from the way that Detective Penner runs.
Of course, Sergeant Hodges. Now, the next day you participated in an interview with Lee Hayes, isn't that right?
I did, yes.
And during this interview, Lee Hayes identified Detective Penner as the shooter, isn't that right?
Yes, he did.
And you didn't believe Lee Hayes, isn't that right?
No, I didn't believe Lee Hayes.
And so in the end, you cut the interview off early, didn't you?
I cut the interview off early because of the way that Detective Cochran was offering up specific information to Lee Hayes, and this would create a bias that was not based on Lee Hayes' own perception.
Well, let's get into why you cut the interview off early. Now, you've known Detective Penner for a long time, isn't that right?
I have, yes.
You trained him back in 2006, isn't that right?
I did, yes.
And you were partners for 2 years, correct?
Yes, from 2006 to 2008.
And you would go so far as to say that he is the best partner you've ever had, isn't that right?
I would, yes.
And he can chase down even the fastest of criminals, correct?
He can.
And now, Sergeant Hodges, you've been grateful for Detective Penner's speed in the past, isn't that right?
I have, yes.
In one particular incident, a driver you had pulled over pulled out a gun on you, isn't that right?
That is correct, yes.
And Detective Penner came over and twisted the gun out of the driver's hand, correct?
Yes.
So in this case, Detective Penner saved your life that day, didn't he?
Yes, he did, and I would have done the exact same thing for him.
But it is correct that Detective Penner saved your life?
Yes.
Thank you, Sergeant Hodges. Your Honor, no further questions.
Any redirect?
Briefly, Your Honor. Firstly, Sergeant Hodges, does your work relationship with Detective Quinn Penner have any influence on your testimony here today?
Absolutely not.
And for clarification, were there any similarities between the way Detective Penner runs and the way the shooter ran?
No.
And again, for clarification, were there any instances prior to the interview where Officer Cochran and Lee Hayes came in contact?
Yes, Officer Cochran was the one who drove Lee Hayes to the station. Was this before or after Lee Hayes identified Detective Pinner?
Before.
Thank you, Your Honor. No further questions at this time.
Any recross?
No, Your Honor.
All right, you may step down. Thank you. Call your next witness, please.
Yes, Your Honor. Defense now calls Sam Maddox to the stand.
Raise your right hand, please. Do you solemnly swear that the testimony you are about to give will be the truth in accordance with the rules of the mock trial competition?
I do.
You may be seated. You may proceed.
Good morning. Please introduce yourself to the judge and members of the jury.
Good morning, my name is Sam Maddox.
And Ms. Maddox, what is your occupation?
Well, I actually work at the zoo right down the street. I'm the facility manager and the animal trainer there.
And what specifically do you do as an animal trainer?
Well, that's definitely my favorite part of the job. You see, I specialize in gorillas, so I like to stick around with one of our gorillas named Penelope all the time, and we'll do training sessions with her, sometimes some shows, and I'll answer questions from our visitors. It's so much fun. I just love it.
And what specifically do you do as a facility manager?
Well, it's definitely a more important aspect of our job. I have to, you see, our zoo is very, very large, so I have to walk around the premise throughout the day, make sure all the paths are clear and safe for all of our visitors, and I get to talk to them as they pass by. And at night, I check the fences and the exhibits to make sure everything's up to standards and are safe for everyone. However, in the past few months, I've noticed a lot of local gangs trespassing on zoo grounds and doing gang activities.
And you mentioned local gangs and gang activity. What has this experience been like?
Honestly, it's been terrible. It's such a safety hazard for all of our animals. And God forbid any of our visitors find a needle or something on the ground and report it.
And Miss Maddox, have you ever had the occasion to come across Orson Hayes?
Yes, it was October 2018.
And can you explain to the jury what happened in October of 2018?
Of course. I was just doing my nightly rounds, checking everything, making sure everything was safe. And I noticed this really large guy just climbing over the fence. So I immediately stepped back and hid behind a tree and took some pictures.
And what happened next?
Well, I called the police and Detective Penner actually showed up. And he started to arrest Orson Hayes, but Orson bolted away, and as Detective Penner caught up and started to arrest him, Orson was screaming and, cursing the whole time.
And have you ever come across Orson Hayes after October of 2018?
Yes, it was actually May 9th, 2019 when I next saw Orson Hayes.
And can you explain what happened on May 9th?
Yes, so again, it was just 10 p.m. I was doing my regular rounds. The snake exhibit actually was getting renovated, so I wanted to go check on it and make sure everything was safe. And when I walked past, I heard these two really deep voices arguing, sounding like they were angry, and I recognized one of them to be Orson Hayes.
And why do you believe that it was Orson Hayes?
Well, Orson Hayes has trespassed on the zoo grounds multiple times, and when Detective Penner was arresting him, he was screaming, so I recognized his voice.
And now, back to the conversation. What specifically was being said to Orson?
Objection, Your Honor. Hearsay, if I may proffer.
You may.
Your Honor, we have a good faith basis that the witness is about to give a testimony based on hearsay statements. If I may walk you through a couple of the specific statements to clarify.
May I respond, Your Honor?
You may.
I don't believe this witness has given any specific statements yet, therefore I believe this objection is premature and improper, and when these statements do come out, and if they do come out, then I believe opposing counsel can raise her objection then, and defense will respond with the appropriate exceptions.
Excuse me, may I respond?
You may.
Whether or not the witness does elicit statements, it is still not admissible if the witness testifies based on hearsay statements. That is why I would like to clarify this and clarify it for Your Honor that it is inadmissible through hearsay.
May I respond?
No, that's not necessary. Overruled at this time.
Yes, Your Honor.
You may proceed.
And now, Ms. Maddox, can you explain what these two voices were conversating with?
Well, of course. From what I heard, they were just talking about some drug dealings and money, and this big guy, who I think was Orson Hayes' drug boss or something, started threatening and screaming at Orson that if he doesn't give him the money now, this 50 grand right now, that he was supposed to get through the drugs that he was supposed to sell, He'll end up at the bottom of the alligator pond at the zoo.
Objection, Your Honor. I renew my objection, if I may proffer now.
You may.
Your Honor, the statements that the witness has been summarizing and also explicitly stating, one is I've given you enough time. Opposing counsel is offering this for the truth to show that Orson Hayes had a deadline approaching. As far as you owe me over 50 grand for the drugs you're supposed to sell through your dealers, that does not fall under any hearsay exceptions. Therefore, it is inadmissible, and opposing counsel cannot be offering this for the truth.
May I respond, Your Honor?
You may.
Your Honor, it is the defense's theory in today's case that there is a third party, this drug boss and gang that Orson was affiliated with, and it is the defense's theory that Orson Hayes' death was caused by this third party, and furthermore, the statements that opposing counsel has mentioned would fall under 8033, then existing mental, physical, or emotional condition, and it would fall under the intent, motive, or plan that the drug boss had to harm Orson Hayes.
May I respond, Your Honor?
You may.
The statement, you owe me over 50 grand for the drugs you're supposed to sell through your dealers. As opposing counsel said, this involves a third party. 8033 only allows the plan of the declarant. In this case, it also involves the third parties of the drug dealers. Therefore, this is inadmissible. Opposing counsel cannot be offering these statements since it is not the plan of the declarant himself. We cannot enter the mindset of the drug dealers, who are the third party, as opposing counsel
May I respond, Your Honor?
You may.
This witness testified that the plan or intent of the drug boss, if he wasn't given the money that Orson owed, is that Orson would find himself at the bottom of the alligator pond, which I believe is the threat and intent and motive that the drug boss had if Orson didn't owe back the money.
May I respond, Your Honor?
Not necessary. The objection is overruled. I will allow the testimony as an exception to the hearsay. You may proceed.
Yes, Your Honor.
And Ms. Maddox, was anything else said?
Well, yes. Orson Hayes just sounded so scared and frightened, and his voice was shaking when he was talking to the drug boss and begging for more time. So again, the drug boss screamed at him, "I'll give you until May 25th and not a day later."
And Ms. Maddox, what day was Orson Hayes murdered?
May 25th.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Now, Ms. Maddox, you detailed a conversation that you overheard on May 9th. I'd like to clarify for the jury what exactly you heard and saw that night.
All right.
Now, it was 10 p.m., so you would have to admit it was dark.
Yes, it was a little bit dark outside.
You were hiding around the corner.
Of course, I was terrified. I didn't want to get caught up with all this.
You didn't get a close look at the individuals.
No, I did not.
You couldn't identify the gender of the individuals making threats that night.
No, I recognized the two voices prior to be two deep voices, but a little bit later there was another person that came into the whole situation after Orson Hayes left, and that's when I couldn't identify the gender.
So that is a yes to clarify.
Yes.
Now, you never saw the individual that you believe was Orson Hayes.
I didn't see their face, but I recognized Orson's voice very clearly.
Now you say you recognized it, but you cannot be 100% certain that it was Orson Hayes speaking, can you?
I can't be 100% certain, but it sounded just like Orson.
Now, you were alone at this time, weren't you?
I was.
There were no other witnesses there that can corroborate that this supposed conversation actually took place.
I mean, besides Ruth the Python, I guess no one else was there.
So that is a yes?
Yes.
So we can only take your word that this conversation took place?
Well, yes.
Now, let's be frank, Miss Maddox. You didn't like Orson Hayes, did you?
Well, of course not. He was a safety hazard to all of my animals and the visitors at the zoo.
Right. You said he was a safety hazard. You believe he was one of the individuals dealing drugs at the zoo?
Yes.
You believe you saw him as early as April 2018?
Yes, that's when I first saw Orson.
Right. Now, in October 2018, you believe you saw Orson once again at the zoo, correct?
Well, of course. When Orson was getting arrested, I heard Detective Penner scream, "Orson Hayes, you're under arrest," so I just figured that was Orson.
No, we'll get to that in just a second, but you did see Orson in October 2018, or you believe you saw him?
Well, I know I saw Orson, yes.
Well, okay. Now, you called the defendant, and he came right away.
Of course.
Now, the defendant had an altercation with Orson, correct?
I guess so. He was arresting Orson, and Orson was, again, running away. And I don't know proper police protocol for that, but Detective Penner did chase after Orson.
All right, let's break that down for the jury. Now,
the defendant handcuffed Orson, correct?
Yes.
He was admittedly rough with Orson.
I thought it was a little bit rough at first, but again, I don't know proper police protocol when the person getting arrested is running away.
I'm not asking if you know proper police protocol. I'm just asking that the defendant was admittedly rough with Orson, correct?
Correct.
Now, once the defendant handcuffed him, he frisked Orson.
Well, yes.
But the defendant didn't find any drugs on Orson, did he?
Not to my knowledge.
Yet the defendant hauled Orson off regardless.
Well, Orson Hayes was trespassing after hours on zoo grounds.
So that is a yes.
Well, yes, because he was breaking the law by trespassing.
Now, the defendant seemed pretty disgusted that Orson got off with just a warning for trespassing, correct?
Correct.
And you were disgusted as well.
Well, yes. I mean, these drug dealers keep coming into my zoo time and time after again, and it's a safety hazard for the visitors and the animals, and it just worries me so much.
Right, it worries you, and the defendant shares this frustration towards drug dealers, correct?
Correct.
Now, the defendant at one point even said that he would do everything possible to catch the perps.
Well, yes.
The defendant even said the zoo should be reserved for zoo animals for little kids to enjoy. It's our job to keep these other animals away by whatever means necessary.
Well, of course.
Objection, Your Honor, more prejudicial than probative.
Your Honor, may I respond?
You may.
The probative value highly outweighs the prejudicial, as it is the state's theory that Detective Penner had a motive towards drug dealers and that frustration. Therefore, the probative value highly outweighs the prejudicial. To clarify for the jury that this is how Detective Penner's attitude was towards drug dealers.
May I respond, Your Honor?
You may.
These statements were not specifically made about Orson Hayes, which is what this trial is about. I believe that it is more prejudicial than probative.
Your Honor, may I respond?
You may.
I'm simply asking the witness if the defendant stated this statement. I'm not asking if it specifically went to Orson Hayes, but the probative value does highly outweigh the prejudicial, as I'm just asking if the defendant stated this to show his attitude towards those matters.
May I respond?
No, not necessary. The objection is overruled. I'll allow the testimony.
Yes, Your Honor.
Yes, Your Honor. Now, Ms. Maddox, the defendant even at one point stated the zoo should be reserved for zoo animals for little kids to enjoy. It's our job to keep these other animals away by whatever means necessary, correct?
Well, of course, anyone trespassing after zoo hours, that's not okay, and that's very unsafe.
Right, you agreed with that statement, didn't you?
Well, of course, because my main priority, again, is to keep my animals safe.
Right, now when you learned Orson was shot and killed, you were not upset, were you?
Well, of course I was heartbroken that a life is gone, but I can't say that I was very upset that one of our repeating offenders is gone.
Right, you were not upset that a repeating offender was gone because Orson was just another animal to keep away by whatever means necessary.
Well, I personally wouldn't call him an animal, but again, he was posing a big safety hazard towards all of the animals in my zoo.
You would agree with me that Detective Penner stated that these animals should be kept away by whatever means
Objection,
necessary.
Your Honor. Asked and answered. I believe this witness has already answered that question.
Sustained.
Yes, Your Honor.
Move to strike, Your Honor.
So stricken.
Yes, Your Honor.
Now, Orson had to be kept away by whatever means necessary, correct?
Well, I guess so, yes.
Thank you, Your Honor. No further questions.
All right. Any redirect?
Yes, Your Honor. Ms. Maddox, why do you believe that it was Orson Hayes on the night of May 9th?
Well, I've seen Orson Hayes trespassing multiple times, and it didn't shock me when I saw him there.
No further questions, Your Honor.
Any recross?
Briefly, Your Honor.
Right.
But to clarify, you never actually saw the individual that you believe was Orson Hayes, did you?
I didn't directly see their face, correct, but I could clearly hear that it was Orson Hayes.
But you cannot be 100% certain it was Orson, can you?
I can't be 100%, but it sounded just like Orson.
Thank you, Your Honor. No further questions.
All right, very well. The witness may step down. Thank you, ma'am.
Thank you.
Call your next witness, please.
Yes, Your Honor. The defense calls to the stand Detective Quinn Penner.
Step forward, please. Raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth according to the rules of the mock trial competition?
Yes, Your Honor.
Thank you. You may be seated.
May I proceed, Your Honor?
You may.
Good afternoon. Please introduce yourself to the judge and the members of the jury.
Good afternoon. My name is Quinn Penner.
Now, Mr. Penner, we've heard a lot today about what you did or didn't do, so I'd like to ask you directly. Did you kill Orson Hayes?
Absolutely not. I became a police officer to catch the criminals, not become one.
Now, I'd like to talk a little about your background. Are you currently employed?
Yes, I am the Vice Squad detective at the Utopia City Police Department.
And how did you become a detective?
Well, I've always been drawn to helping people, and I believed the best way to do that was to start a nonprofit and major in business. But this all changed my sophomore year of college.
How did everything change for you this year?
Well, my best friend and roommate was murdered in a drive-by shooting. I thought the best way to help my community at this point was to become a detective or a police officer, help out.
And how long have you been with the Utopia City Police Department?
It's been about 15 years now.
Have you been promoted at any point during this time?
Yes, actually I was promoted just 2 years after working as a patrol officer to Vice Squad detective, my current position.
Is it common for a newly hired patrol officer to be promoted so quickly within their career?
Actually, not really. And I was really proud of my promotion, but it created some animosity around the station.
How so?
Well, a few of my fellow officers, especially Officer Cochran, they were talking badly about me and seemed jealous of my promotion.
And who is Officer Cochran?
Officer Cochran is the lead investigator on this case.
Based on your personal experiences, why did you believe that Officer Cochran was jealous of you?
Well, in a few of my past investigations, Officer Cochran was trying to paint me in a bad light and believed I was doing things incorrectly.
Objection, Your Honor. Speculation.
May I respond, Your Honor?
You may.
I believe that the witness has laid proper foundation as to the actions of Officer Cochran, and therefore it's his rationally based perception that he was trying to do these things, which would be a proper lay opinion under 701 and is not speculative.
May I respond?
Not necessary. The witness did indicate that it was based upon his personal experiences and perception. I'll allow the testimony.
Yes, Your Honor.
Yes, Your Honor. May I proceed?
You may.
Now, Detective Penner, based on your personal experiences, why did you believe that Officer Cochran seemed jealous of you?
Well, he was talking badly about me and always just tried to get me in trouble. He just seemed very jealous.
And is it common for an officer to be allowed to be a part of an investigation when they have a personal connection to one of those involved?
No, there's always a potential for bias.
And what do you do as a member of the Vice Squad?
We mainly focus on apprehending drug dealers and stopping illegal gambling.
Now, I'd like to talk about your relationship with the decedent in today's case, Orson Hayes. How did you first come to know Mr. Hayes?
Orson Hayes was on our radar for quite a while. He was a repeat offender.
And when was the last time that you had contact with Mr. Hayes?
Just the day before he was murdered, May 24th.
What happened during this encounter?
I decided to stop by the bank on my way home from work when Orson Hayes was at the bank counter pointing a gun at the bank teller demanding money to be put in a bag.
And what did you do when you saw this?
Well, other customers were just cowering against the wall, so I decided it was in their best interest to apprehend Orson. I lunged forward to try to grab Orson's gun, but he clawed my arm.
And did Mr. Hayes get away?
Yes, he fled the scene, but we were going to catch him eventually. He was facing upwards of 10 years in prison.
Now, have you heard the testimony of Chris Benson in court today?
Yes, I have.
And are you aware that your DNA was found under the fingernails of Mr. Hayes?
Yes, I was, and that's easily explainable. At the bank just the day before Orson clawed my arm, that would explain why my DNA was under his fingernails.
Objection, Your Honor. Speculation. May I explain?
You may.
As the witness is not an expert in forensic evidence, he would not know if this scratching will be able to place this evidence there, still there on the night of May 25th. This has already been explored on Mr. Vincent's cross and is more proper to be entered in that cross-examination.
May I respond, Your Honor?
You may.
As witnesses are not sequestered in accordance with the rules of competition, Mr. Penner has heard all of the testimony from Mr. Vincent, who did say on his direct as well as cross-examination that DNA can be left from an altercation such as a scratch, and therefore it wouldn't be speculative, as he's heard that testimony in court today, as well as he is a detective and would have some understanding of forensic, not forensic knowledge specifically, but of investigations of this sort, and therefore would be qualified to testify on it.
May I respond?
You may.
Yet again, Detective Penner is a lay witness. He's not an expert in forensics, just as opposing counsel stated, and because of this, he cannot testify to whether or not this scratching would indeed explain whether or not this forensic evidence was placed there under the victim's fingernails. This could only be done through an expert witness like Mr. Vincent.
May I respond, Your Honor?
You may.
I'm sorry. Again, in accordance with Rule 4.9 of the Rules of Competition, witnesses are not sequestered and therefore would be able to hear the testimony of other witnesses. He's just simply explaining an encounter that Mr. Vincent has testified to. It would not be speculative in any capacity, as he's heard from Mr. Vincent himself, as well as his understanding of the events as they occurred. It's rationally based on his perceptions.
I'll sustain the objection to the extent that the response of the witness goes beyond the factual testimony of what transpired at the bank itself, and the clawing is testified to by the witness.
Move to strike.
So granted?
Yes, sir.
Yes,
The
Your Honor.
jury will disregard the latter portion of the answer with respect to the opinion of witness Penner.
May I proceed?
You may.
Now, Detective Penner, are you aware that your DNA was found in the alley behind Paradise Pub?
Yes, I am.
And do you often go to this alley?
Yes, I do. After my workouts at Jamie Spalding's gym, I frequently decide to smoke a cigarette after my workouts, and I worked out just the day before Orson was murdered.
And just generally, where is Paradise Pub?
Paradise Pub is in downtown Utopia.
And would you recognize a map of the area if I were to show it to you here today?
Yes, I would.
Your Honor, may I approach the bench to retrieve what's been previously tendered as Exhibit 3?
Yes, you may.
And may I approach the witness?
You may.
Mr. Penner, is that an accurate copy of the map of downtown Utopia?
Yes, it is.
And Your Honor, may we request that the witness be able to step down to show the jury the image itself, as the labels are quite small and he'll be referring to specific statements on the document?
I believe that was presented to the jury as well, and they have that. So I think if the witness just refers to the key on there, you should be fine. Not necessary.
Yes, Your Honor. Detective Penner, can you please indicate to the members of the jury where it is that you go to smoke?
Yes, so Spalding's gym is right here at number 2, and I smoke in the alley right across the street.
And where were you on the night of the murder, May 25th?
I was all the way across town at the bar.
And can you estimate the distance between Rubicon Sports Bar and Paradise Pub where Orson Hayes was murdered?
It's almost a mile.
And what were you doing at Rubicon Sports Bar on May 25th?
Nothing unusual. We were just eating and drinking, watching the NBA game.
And were you with Jamie Spalding all night?
No, I left around 11:45 just to go into the parking lot and smoke a cigarette.
And how long were you gone from Jamie Spalding's site?
Just 15 minutes.
Now, Detective Penner, would it have been physically possible for you to run from Rubicon Sports Bar all the way to Paradise Pub and all the way back in just the 15 minutes that you were gone from inside Rubicon Sports Bar?
Absolutely not. I would have to leave the sports bar at 11:45, run all the way across town, almost a mile away, wait for Orson, murder Orson, dispose of all of that evidence, and run back in just 15 minutes. That's impossible.
Thank you, Your Honor. No further questions at this time. And may I approach the witness to re-tender the exhibit to the bench?
You may.
And may I approach the bench?
You may. Thank you. Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Now, Detective Penner, during your years in the Utopia City Police Force, you have been formally reprimanded on 2 occasions for your dealings with drug dealers. Isn't that right?
That's correct. I've made a few mistakes in my past.
In this first instance, you were reprimanded for...
Objection, Your Honor. This testimony is getting into improper character evidence in accordance with Rule 404.
May I respond?
You may.
Your Honor, under Rule 404A2, I am using this to show a pertinent trait in using this to respond to opposing counsel. If you would take a look at State v. Coltsow, it has been established in the state of Utopia that because we don't have rebuttal witnesses, we are allowed to attack the character of the defendant. And throughout today's trial, opposing counsel has described Detective Penner as a good, just, dedicated police officer. Now if you look at 405B, this is being used as a specific instance of conduct which is allowed in the state of Utopia.
May I respond, Your Honor?
You may.
Pursuant to Rule 404B1, crimes, wrongs, and other acts, in this instance, opposing counsel is referencing a specific wrong or other act. A prohibited use of a crime, wrong, or other act is not admissible to prove a person's character in order to show that they acted on that particular occasion. And with regards to State v. Kelso, while it does say that the state is allowed to offer character evidence during its case in chief and cross-examination, it does not go to the admissibility of this character evidence. It still must conform under Rule 404, and as this violates 404B, the prohibited use of crimes, wrongs, and other acts, it would still be inadmissible in court today.
Brief response, Your Honor.
You may.
I'm not using this to show propensity, because in fact in today's case, Orson Hayes wasn't murdered during a witness interview. Instead, I'm using this to show the defendant's pertinent trait, which under State v. Coltsow, we are allowed to attack on cross-examination, and under 405B, we are allowed to do this through specific instances of conduct, which these two instances are.
And what is the pertinent trait at issue here then?
The pertinent trait would be the animosity that Detective Penner has shown towards drug dealers, as the defense has been trying to paint Detective Penner as a good, just, dedicated police officer that wouldn't do something like this. They're simply using this testimony to rebut that trait.
May I respond, Your Honor?
You may.
I believe that opposing counsel just stated that they are going to show that because they acted in accordance with frustration or animosity towards drug dealers in that instance, that he would act against Orson Hayes, which goes to show propensity and which would violate 404B1. He's using a crime, wrong, or other act to show a character trait, in this case animosity or frustration. And again, in accordance with State v. Kelso, it does not automatically make character evidence admissible, just that the state may offer it as long as it conforms to 404, which this does not. It violates 404B1.
All right, the objection is sustained, and so that line of questioning is not permitted.
Yes, Your Honor.
Yes, Your Honor.
Now moving on, you've had many encounters with Orson Hayes throughout your career, correct?
I have. Orson Hayes is a repeat offender.
That's right. In fact, you would say you've had a long, frustrating history with Orson.
That's correct. He's gotten off pretty easily in the past.
Now, let's talk about those instances.
Okay.
Now, the first time you encountered Orson, he was lying on the couch of a suspected drug dealer. Isn't that right?
That is correct, yes.
And in that instance, you were unable to charge Orson with anything, were you?
Right. We were only able to send him away on a warning.
That's right. He got away with no charges.
Correct, yes.
So Orson had gotten away for the first time. Isn't that right?
Yes, that was the first time.
And the next time you encountered Orson, he was driving under the influence of and in possession of marijuana, correct?
Yes, he was.
And in this instance, as you would put it, Orson got away with a slap on the wrist, didn't he?
That's correct. These first few initial instances in which we've encountered Orson Hayes have been very minor, but the bank robbery, the day before he was murdered, he was going to be put away for a pretty long time.
We'll get to the bank robbery in a moment, but for now I'd like to stick with these instances. Now, for his possession and use of marijuana, you were again unable to charge Orson. Isn't that right?
That's correct.
In fact, at that point, he got away again with no charges.
Yes.
And the next time you encountered Orson, he was actually dealing marijuana, wasn't he?
That is correct, yes.
And he was charged, but only for 6 months in prison, correct?
Yes. Since this was one of his first instances, it was a very minor charge.
So 6 months later, and Orson was back in the streets, wasn't he?
That is correct, yes.
And that frustrated you, didn't it?
Initially, yes, it was a little frustrating, but we knew we were going to eventually get Orson for something bigger, such as a bank robbery.
Well, soon you began to suspect that Orson was actually dealing methamphetamine, didn't you?
Yes, we did. We also suspected he had some sort of gang affiliation.
But you didn't have enough evidence to charge Orson yet again, did you?
Yes, we weren't able to charge him yet.
And yet again, you were very frustrated by this, weren't you?
Yes, I was pretty frustrated in these first few instances.
In fact, at this point, you began to seek out alternative methods to get information against Orson.
We did try a few alternative methods, like inserting an undercover gang member, but these were unsuccessful as well.
That's right. In addition to having an undercover gang member investigate Orson, you also tried to bribe informants, didn't you?
That's correct. That was another one of our methods.
But none of these methods worked, did they?
No. Like I said, initially we were very unsuccessful, but the bank robbery, he was going to be put away for over 10 years.
But in this instance, Orson got away yet again, didn't he?
Yes, these minor charges we weren't able to charge him for.
Now let's talk about that bank robbery. Now on May 24th, you entered the bank to see Orson holding a gun to the head of a bank teller, didn't you?
That's correct, yes.
And at that point, you tried to apprehend him, but he ran out the front door, didn't he?
Yes, he did. I tried to grab his weapon, but he clawed my arm, and I ended up chasing him out of the bank.
Once he left that bank, he got into a getaway car and drove on off, didn't he?
That's correct, but he did leave behind some evidence that would lead us to believe Orson was the suspect.
Now, you didn't have enough, well, you weren't able to catch Orson in this instance, were you?
No, but we believed we were going to be able to charge him.
So Orson had gotten away again, hadn't he?
Yes, but he was going to go to jail for a very long time.
Well, Detective Penner, in fact, Orson had gotten away for the last time, hadn't he?
That is correct. This was Orson's last, yes.
Now, at this point, you wanted to continue serving on Orson's investigation, correct?
Yes, I wanted to put Orson in jail, and along with my colleagues, we believed we were going to be able to do so.
But your chief of police wouldn't let you do that, would he?
No, I'd worked pretty late that night. He just sent me home.
Well, he didn't just send you home. In fact, he placed you on administrative leave, didn't he?
Yes, it was basically just told me to go home, get some rest, and come back later.
But you didn't want to follow orders, did you, Detective Penner?
No, I was pretty passionate about this investigation. Orson was a repeat offender, and I believed we were going to be able to put him in jail.
In fact, at this point within the law, all you could do was give your witness statement and turn in evidence, correct?
That's correct, and I did just that.
Well, you didn't, did you? In fact, you withheld evidence in this case. Isn't that right?
That accidentally, yes, I kept the phone in my pocket, but when I realized I had it on my person, I turned it in immediately.
But you were in possession of Orson Hayes' cell phone for 6 hours without turning it into evidence.
Yes, right after I was told to leave, I went home. The cell phone was still in my pocket. I took a nap, but when I realized it was in my pocket, I turned it in immediately.
And that's not standard procedure, is it?
No, unfortunately, I forgot about the cell phone.
All right, now finally I'd like to ask a few clarifying questions for the members of the jury.
Okay.
First, Detective Penner, you would describe yourself as a fast runner, wouldn't you?
Yes, I am a pretty fast runner.
And that is despite many people describing your running motion as funny or odd and jerky, isn't that right?
That's correct, yes.
Now finally, Detective Penner, you aren't right-handed, are you?
No, I'm left-handed.
That's right, you are left-handed.
Yes.
Objection, Your Honor, asked and answered. The witness did answer the question in his previous statement.
Overruled.
Yes, sir.
So you are left-handed?
Yes, I am left-handed.
Your Honor, I have no further questions.
All right, cross-examination, or excuse me, any redirect examination.
Yes, Your Honor. May I proceed?
You may.
Now, Detective Penner, were you concerned that Orson Hayes wasn't going to serve proper punishment after he robbed the bank on May 24th?
Absolutely not. My colleagues and I believed that Orson was going to go away for upwards of 10 years. He had possession of firearm and attempted robbery. Those were going to be very significant charges.
And during the bank robbery, did you intend to withhold evidence in any capacity?
No, I did not. I honestly forgot about it, and I never looked at that cell phone.
Now, finally, opposing counsel had asked you about how fast you run, but would you have been able to run over 2 miles in under 15 minutes?
No, I can run fast, but I just had a lot of food and drink. There was still traffic from the NBA game. It's impossible for me to run almost a mile across town and back within 15 minutes.
Thank you. No further questions at this time, Your Honor.
Thank you. Any recross?
Very briefly, Your Honor.
Proceed.
You may.
Now, on redirect examination, you stated that you believed you were going to be able to charge Orson for this bank robbery, right?
Yes, we were able to charge Orson. We were going to be able to.
But up to this point, you still hadn't been able to charge Orson with
Objection,
anything.
Your Honor. This question is outside the scope of my redirect. May I proffer?
You may.
While I did ask about the specific instance of Orson being charged for the bank robbery, I never got into any of his other acts. Therefore, it would be outside the scope of my redirect to ask on recross whether he would have been put away prior to this instance.
Response, Your Honor.
You may.
I'm only using this to show the bank robbery instance and showing that he wasn't able to hold Orson at that point accountable for the bank robbery.
I'll allow it. The objections overruled.
Yes, Your Honor.
So at that point, you still hadn't been able to hold Orson accountable within the law.
Well, the investigation had just started, and we had enough evidence to put Orson away. We were going to.
An investigation that legally you weren't allowed to continue.
No, but my colleagues are very professional, and they would have put Orson away.
No further questions, Your Honor.
All right. Thank you. The witness may step down.
Thank you.
Any further witnesses by the defense?
No, Your Honor. The defense rests its case in chief.
All right. All right. With the close of proof then, ladies and gentlemen, it is time for us to take another brief recess before we hear closings from the parties. So we'll go ahead and be in recess for about 5 minutes, and then we'll get started with closing statements. Thank you.
Yes, Your Honor.
You may be seated. All right, it's that portion of the trial where we have closing argument. Is the prosecution ready to proceed?
Yes, Your Honor.
All right. Whenever you are ready.
May I proceed? May it please the court. In order to stop a criminal, he became one. When Orson Hayes stepped out into the alleyway beside Paradise Pub, he wasn't alone. There was a criminal in that alleyway, and it wasn't Orson Hayes. The criminal in the alleyway that night was Detective Quinn Penner. A remarkable conclusion, but an inescapable one. Now, as the prosecution in today's case, we bore the burden of proof. We had to prove that the defendant murdered Orson Hayes beyond a reasonable doubt. Now, members of the jury are providing eyewitness testimony and corresponding forensic evidence. We have met that burden today. Let's walk through that evidence. First, you heard from Miss Lee Hayes, the victim's cousin who was just feet away from him when he was shot and killed. Miss Hayes described what she saw that night. She saw someone the same height and build as the defendant enter the alleyway. The defendant walked over, placed his right hand on the alley wall, pointed a gun at Orson with his left, and fired. At that point, Orson's body dropped to the ground, and the defendant fled. He fled in an odd, jerky manner. The same odd, jerky run Miss Hayes had seen just the day before. But as the defendant ran away so uniquely, he made a mistake. Because as Chris Vincent explained earlier, the forensic evidence left at the scene of the crime aligns perfectly with the eyewitness testimony of Miss Lee Hayes. The defendant's DNA was found both under the victim's fingernails and on a cigarette pack left at the scene of the crime. You also learned that the defendant's fingerprints were found on the alleyway wall. The same alleyway wall where the defendant placed his hand before murdering Orson Hayes. Now you learned from the defendant himself today that he withheld evidence. He was in possession of Orson Hayes' cell phone. A phone which contained a message detailing exactly when and where Orson would be on the night of the 25th. Now, rather than turning this information over to his supervisor, the defendant used this information to devise his own alternative sentencing plan, where he served as judge, jury, and executioner. Now, Ms. James Spaulding described how the defendant put this alternative plan into practice. At 11:30 that night, the defendant stepped out for a smoke break. The defendant was gone for nearly half an hour, and when he returned, he was sweaty and out of breath, like he'd just been on a run. At that point, Ms. Spaulding began to ask questions. Why had the defendant been gone so long? Why was he so sweaty and out of breath? Where had the defendant been? Well, soon Ms. Spaulding's confusion turned to horror when she learned of Orson Hayes' death. She recognized that name. Orson was a criminal the defendant always complained about getting away with stuff one too many times. Members of the jury, at that point the defendant's alternative plan became clear. He wasn't going to let Orson get away with anything any longer. The night of May 25th, he traveled from Paradise Pub and back that evening. That's why he was gone so long. That's why he was so out of breath and sweaty. That's where the defendant had been. Detective Penner had murdered Orson Hayes, because in order to stop a criminal, he became one. Thank you.
Thank you, counsel. Is the defense ready to proceed with its closing argument?
Yes, Your Honor. May I proceed?
You may.
May it please the court, opposing counsel, and members of the jury. They saw Quinn Penner, and they didn't look further. Now, members of the jury, being focused on something can be a good thing. We can become passionate, driven, unwavering in our commitment to achieve a goal. But being too focused, having tunnel vision, can lead us to muddy the facts and prevent justice. Members of the jury, throughout the course of today's trial, we have learned that there was another probable suspect for the murder of Orson Hayes. One that the prosecution failed to investigate because they saw Quinn Penner and they didn't look further. Now let's walk through the timeline. Just 2 weeks before the murder of Orson Hayes, you heard Sam Maddox sit here and testify that Orson's life was being threatened. Orson was told that he owed his drug bosses $50,000, and that if he didn't pay up, he would find himself at the bottom of the alligator pond. Now, members of the jury, Quinn Penner didn't make these threats against the life of Orson Hayes. But did the state investigate who did? No, because they saw Quinn Penner and they didn't look further. Members of the jury, just 2 days before the murder of Orson Hayes, a meeting was scheduled. His drug bosses told them that they would meet Orson at Paradise Pub at 11:45 on Saturday, May 25th, and that he'd better have their money, or else. Now, members of the jury, who made this meeting with Orson Hayes on the night of his murder? It was not Detective Penner. But did the state investigate who did? No, because they saw Quinn Penner and they didn't look further. Members of the jury, I want you to ask yourselves, when was the murder of Orson Hayes? At 11:45 on Saturday, May 25th, outside Paradise Pub. Now, members of the jury, on the night of the murder of Orson Hayes, he received even more threatening texts. Were they from the defendant, Detective Penner? No. Orson Hayes was told that tonight is the night. You're going to regret if I have to hunt you down. Members of the jury, just 4 minutes before the murder of Orson Hayes occurred, he was told, I'm almost there. Now, what did the state do when they saw that Orson Hayes was threatened 4 minutes before his murder? Nothing. Because they saw Quinn Penner and they didn't look further. Members of the jury, it is the burden of the state in today's case to prove beyond a reasonable doubt that the defendant Quinn Penner did knowingly and recklessly murder Orson Hayes. And that is a burden that they have simply not met. What evidence does the state rely on in today's case? They rely on Lee Hayes, an eyewitness to the murder. But recall, Lee Hayes sat right here and told you that she could not be 100% certain that it was Detective Penner in the alley that night, that it was dark, that she was over 20 feet away. Members of the jury, that is not proof beyond a reasonable doubt. What else does the prosecution rely their case on? DNA evidence. DNA evidence that's simply explained by an encounter the day before. But what did the state do when they learned that Detective Penner had a reasonable explanation for this encounter? Nothing. Because they saw Detective Penner and they didn't look further. Members of the jury, the state came before you and told you that to catch a criminal, Detective Penner became one. But in reality, to prosecute a criminal, the state invented one. Which is why we ask you to find the defendant not guilty, as it's the only verdict that the facts compel, the law requires, and justice demands. Thank you.
Thank you, counsel. Any rebuttal?
Yes, Your Honor. Before I begin, may I ask how much time I have left?
You may.
33 seconds.
May I proceed? Opposing counsel just came before you and asked you to look further. Members of the jury, I'd ask you to look at the facts. Ms. Hayes, the only eyewitness of this crime, saw someone the same height, build, and had the same run as Detective Penner. And the forensic evidence doesn't indicate any unknown individual, but only one individual, Detective Penner as well. In order to stop a criminal, he became one, which is why we ask that you return a verdict of guilty for Quinn Penner. Thank you.
Thank you, counsel. All right. That concludes our trial. And at this time, in addition to some deep breaths, I think it would be appropriate to give a round of applause to all of our let's see here. I would like to have the jurors, if you would please, just introduce yourselves and tell us a little bit about how you are involved with the mock trial program. And if you would like to offer any comments to the participants, that would be great as well. Thank you. Lieutenant.
My name is Patrick Monahan. I'm a local attorney here in Northern Kentucky. Been practicing law about 21 years. Work out in Boone County, Kentucky. Do general practice. I do divorce work. I do criminal work and some estate planning. I'm involved just as a volunteer, just as a local member of the community, and agreed to volunteer to judge this competition. I mean, wow, this is a great ending to a wonderful tournament. I was able to work yesterday and didn't have an opportunity to see either one of these teams perform, and you guys definitely knocked it out of the park. I'll give general comments. I think you guys have been through enough and critiqued over the past couple days. But first of all, just opening statements. You guys were well prepared. You were confident. You guys worked the room better than I've seen most, which helps the jury kind of follow along. And you provided a little bit of storytelling. And I think with setting a foundation in opening and closing, it's very important not just to reiterate the facts, but to give the jury kind of a story to relate to. And I think you made it simple. You made it easy to digest for the jury. You did a wonderful job. As far as witnesses, you guys were, it was like watching CIS or something. CSI or whatever. You guys did, we had actors here. You guys definitely knew your roles. You stayed within the rules, but you didn't let your roles take away from the hearing. So you did a wonderful job. As far as counsel, this was very impressive with the objection practices. I think they nailed their objections. They didn't over-object. They didn't bog down the trial, but they picked effective times to object, and they truly understood what they're objecting to and were able to debate back and forth very, very well. I think you guys did an awesome job of that. Overall, great job. You guys have bright futures ahead of you. Thank you.
Hi, my name's Logan. I'm a first year at Miami University. I do mock trial there, and I did mock trial for 4 years in high school, so I've been doing mock trial since I was 13. A long time. Overall, I've been an attorney all 5 years, and I'm a bit of a rules of evidence nerd. I really like objections and all of that stuff, and I want to say that I was so impressed by all of you. Like, there are people in college that make objections and don't know what they're objecting to, and you guys had such a good grasp of everything you were objecting to, the responses. Some of them were just flawless. And so yeah, I was really, really impressed by that. There was a 404 objection to character evidence, and that's a hard one to argue. It's a hard one to understand. And I thought that it was like perfect how the people argued it. As for witnesses, you guys were phenomenal. Yeah, it's really hard to get witnesses that are like entertaining enough that like everyone enjoys them and it keeps the jury awake and understanding what's happening, but also not taking away from what you're trying to say. And my coach says this all the time, witnesses win ballots. You want entertaining witnesses that are going to win points, and you were all just great witnesses. You had energy, you kept everyone awake and excited and alert, paying attention to what was happening. Yeah, you were both just fantastic teams, better than some of the college teams I go against, so good job.
Thank you.
Thank you.
So my name is Jamie Collins. I am a civil defense attorney, which if you're going to be an attorney, that's the best thing, in my opinion. I like to talk, but I'll keep it short. I've been practicing not for 21 years, but for some years now. And I competed at my law school in mock trial. I currently coach Chase's national trial team, so I've been around. And just overall, generally, I've gone up against some really horrible teams in my day. I've had really bad partners. I've had really good ones. And everyone here, in terms of how well they were prepared, they knew the facts, you knew your story, you knew your theme, and nobody really wavered. And that's hard to do at the collegiate level in law school, and you guys did it perfectly. I would have loved to have any of you next to me when I was competing, so it was really, really good. Just before general comments, has this team competed against each other in this tournament?
No. Last year.
But was it a different case?
Yes.
So the whole murder, he wanted to get criminals, but he became one. That was your theme overall. And that's important in terms of mock trial, having that theme throughout and spreading it out throughout and sprinkle it in here with your witnesses. That's where being prepared and having your witnesses be prepared to restate that theme and just sprinkling it here and there really, really comes into play. But on the other end of that, you've got a theme that they absolutely destroyed. On the stand, and that's why I asked, because I was like, how was that prepared? Like he said, I became a cop to catch criminals, not become a criminal. and he just basically turned your theme on its head, but you can't control that, obviously. And then in the closing, they said the state needed a criminal, so they invented one. And I would still stick with that theme, but you know, when you got back up on your rebuttal, I thought that needed to be addressed immediately. Like, we did not invent a criminal. We've got forensic evidence, this, and this. So there wasn't an invention here. I understand you only have 33 seconds left, but I think that was just good on both your parts. I judged some of these competitions, and of these two teams, it was the first team I've seen that actually had a noticeable theme. And it was the first team that actually noticed that theme and tried to flip it on its head. Now, that could have certainly went against you. So I wouldn't say there's points awarded here or there. Just general thoughts on my end. I don't know how you cried. I almost cried. I don't know. I'm like, how? Are they attacking your foot? And then, just you as an expert, I was like, yeah, he did it. Like, I believed you. Like, what do you ranges from 15 to 16, 17 maybe? I believed you were an expert. I believed everything you said. You said it confidently, like an expert would. And then on cross-examination, especially when you're cross-examining experts, I think is very, very difficult. I've seen people try to go in with the mindset of they're going to change this person's mind, and you didn't, because you're never going to change an expert's mind, ever. Very, 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 very rarely. But you didn't. You just said, okay, let's just poke holes, because as the defense, your job is not to prove a case. Your job is just to poke little holes, little holes of doubt, little holes of doubt here and there, in which you did that. And then on redirect, you know, it was let's just reaffirm this, that yeah, it's possible, but you know, it's possible this, it's possible this, but let's talk about what's probable, which you did. You cleaned it up really well on redirect. I mean, you as a witness, you know, bubbly and you know, full of energy, and that was really, and you as well as the zookeeper, you played your roles very, very well. And then, you know, the Lee Hayes, the old cop buddy. I mean, I believed you were a cop. I mean, it was just something that everybody did well. You were a cop, Lee? Oh, yeah, you were a cop, if I remember correctly. But thanks. And then you, I think you were the perfect person to play the cop. Thank you. All-American boy, you know, you got up there, you know, kind of said, no, I didn't want to become a criminal, I wanted to catch him. Openings, very, very, very much on the prosecution side, you have a very tough job of a cop killed a drug dealer. That's what you've got here. You've got a very tough job of trying to convey that in a way to where you get the jury on your side. And I think you did a really, really good job of that. Of saying, listen, I know he's a cop. Essentially what you were saying, I know he's a cop, but he wanted to catch the bad guy so bad it let him cloud his judgment. And that's why he became a criminal, to catch one. And I think that was a really, really good way to play it. You know, on your end, you didn't humanize him, which is really good. It's always the defendant. But on your end, you did exactly what you were supposed to do on opening. And this is a person here. This is Detective Penner. Humanized him right away. Everybody used the court really, really well. I think everybody did just an excellent job. And there's a reason these two teams are in the finals. It's because you were clearly the best of the schools that competed. So congratulations. Good job.
Thank you.
My name is Kendra McCardle. I'm a local attorney. I have an office in Florence. I practice mainly in family law. I do some criminal defense. My background, I've been an attorney for about 12 years now, I think, this year. Don't quote me on that. I'm not good at math. That's why I'm an attorney. I started as a public defender, so I've had the opportunity to do trial work. I've witnessed a lot of trial work. I'm lucky that I get to be in the courtroom all the time, which I really enjoy. You all had a great command of the courtroom. You had great knowledge of your cases. You were confident. You presented better than a lot of attorneys that I see in court on a day-to-day basis, and I'm in awe that you all are in high school. Witnesses, fantastic job acting. It's really hard to take that wealth of information that you were given and make it come across like it's coming out of your mouth for the first time. I know that you guys have been doing this for 3 days now, so I'm very impressed. I also learned I have no mock trial experience at all. This is my first time volunteering because I finally felt like I've seen the email enough times, like, oh yeah, I should go volunteer at something like this. So it's my first experience, and I'm completely floored by the talent that I've seen, but I also didn't realize that you all switched sides throughout the competition. That was news to me. My hat's off to you. You guys are fantastic. I loved it. I hope my son, who's 4, decides to do something like this when he gets to be older. But great job to all of you, and just fantastic. My hat's off to you.
My name's Allison Jones. I'm a judge on Kentucky Court of Appeals. I've been on the appellate bench for, it'll be 7 years this summer. Before that, I was an administrative law judge. I did workers' comp claims in Kentucky, which is a mini version of a trial. And before that, I litigated primarily civil defense work. I thought you all did a really excellent job. I was glad I was not the presiding judge. I was the presiding judge on Friday, and so I'm an appellate judge, and this is very different than what I do, so I find myself saying, well, let me think about this for a couple months and I'll write you an opinion and get back to you on that. But what I saw different, and I hadn't seen these two teams before, was the really judicious use of objections and the meaningful way that you use them and you understood them, both in making them and defending against them. And that was very different from some of the lower rounds that I saw, where I feel like objection would pop out and then it was like, oh gosh, now she's going to ask me, the basis for it. And I thought you all did just a really, really great job. Some of the objections that you argued are difficult to understand and to articulate, and I thought you did better than many attorneys do out there in trying to handle evidentiary objections. I was really, really impressed with the level of poise and confidence that everyone exhibited. I expected, with this being the finals, we would see a little jittery nervousness and uncertainness at points, and I really didn't see any of that. There were a couple instances maybe where somebody would start to say something and then catch themselves, and you all just glossed over it and went on. And I liked, because you don't know how the objections are going to turn out, and so you were able not to let the objections or the responses to those interrupt your flow, and that's really, really important to make it seem like even if you lose it, oh, that's fine, we're going to go ahead and go on. And so I thought that was really good. I think all of you have great talent. I urge you to continue on this path. I hope you'll all think about careers in the law, and that you'll continue to do either mock trial or moot court. Also is the appellate version of this, and it's really interesting, and you more make legal arguments. So those of you that really like dealing with the objections and the evidence and arguing the case law and the rules of the court may be something you want to think about as you're in college or law school even. So anyway, great job. Kudos for making it this far. And I'm going to shut up because I know everybody wants to just hear who the winner is at this point.
Thank you so much.
All right, guys, that was a great and very close final round of competition. So close, in fact, that we had tied ballots. So we had 2.5 ballots versus 2.5 ballots. So in that case, our Kentucky rules state that we follow the AMTA rules, which is our college national organization, to break the tiebreaker. For a championship round, the tiebreaker is whoever has the highest point differential. Okay? So, with that being said, one team had a point differential of plus 16, and the other team had a point differential of plus 14. So, by 2 points, our Kentucky state champion of 2020 is Team K Model Lab.
Okay, Model Lab, I got something for you. Congratulations. We're going to support you in the national tournament coming up. Anything that we can do to help, we will do. It's your responsibility to get the brass plate for your school name right here. And next year, we're going to have to add another level to this tournament. In addition to this trophy, we have another one. The big gap. First place. Congratulations. Thank you. Good job.